Now we gotta go help people customize and save hundreds with Liberty Mutual. Where's the golf cart? Now we gotta go help. And I killed two of them. Yes, they're mortal and
peace and love, peace and love, peace and love. It's your brother again with another one for all the conscious brothers and sisters in the conscious community keeping the struggle. Because we know that it's through the struggle that we grow. Also, I like to say that it is in fact a slow process for progress, and that the race is not, it's not to the swift, it's to those who remain dutiful. So make sure you stay in this for the long haul. Y'all already know that my videos don't constitute legal advice, not an attorney, a lawyer, those type of things. Just your brother sharing education and information about my walks and about my travels throughout my journey called life. I like to extend these times because when you're honoring man and you're honoring woman, you're honoring yourself. Like to give all adoration and acknowledgement to Allah, that's the head to courtesy to his messengers and prophets. Peace to you, beloved brothers and sisters and grandfathers. Chosen ones. How's everyone today? Myself, I'm blessed, taking everything in steps. Today, I'm gonna build on some topics, okay? Because it's a lot of misinformation. In this day and time, it's about correcting information uh, so that people can know the correct way about going about handling certain situations that they may be dealing with. you often hear people say things as if prosecuting attorney committing fraud, courts is uh, doing deceptive acts and practices. It's a lot of things that are being taught by individuals without fully doing research before they start teaching certain concepts and certain topics publicly. You know, let me give you an example. Like a lot of people will tell you that they commit fraud by having you on child support. Well, contract is law, and law is contract. Uh, a lot of people don't understand contracts, uh, and the lack of understanding contracts, agreements could cause you to end up in some type of personal uh, obligation, not understanding how usually, you know, they assert jurisdiction or rights over an individual. Now, when dealing with the courts and stuff like that, you have to learn like the rules of the court. The court has rules, and in order for you to be able to assert yourself properly, you have to learn the procedures and the rules that the court go by. Usually, all actions in court start with a claim. Usually, someone makes a claim with the court, and that claim leads to a service of process and a complaint being filed against the party, right? Now, when you think about court, the court has specific rules, right? So I'm gonna pull up the civil rules of procedure. I'm gonna go to civil rules of procedure. I'm gonna pull up that real quick. All right, because what I want to do is I want to show you that if you just take out a little bit of time to read some of this stuff, you can find answers to a lot of things that is simplified. But the way that this system works is they have time frames and stuff. So if you don't do a specific thing within a specific time, or you do a specific act, and that act is not in reference to what the code requires or what the civil rule, because you got to remember we're dealing with civil matters. Okay, everything we dealing with is civil. So they're using civil law, and you got to learn those laws, okay, in order to be able to do anything. So I'm in the federal rules of civil procedure, right? Now, I want to show you something. And this is very important that you pay attention to what I'm about to show you, because this can change the outcome of a case if you understand this simple thing, right? Now, check this out. Now, when you go to the civil rules of procedure, first rule is rule 1. When you click on rule 1, it says this rule governs procedures in all civil actions and proceedings in the United States District Courts. Now, this is dealing with the district court is a District of Columbia District Court, okay? Except as stated in Rule 81. It says they should be construed, administered, and employed by the court and the parties to secure the justice, speedy, and inexpensive determination of each action and proceeding, right? So when they say construed, that means that they get to legally determine. Now, I always like to go down in the bottom, because when you go down in the notes in the civil rules, the notes break it down to you and give you a better understanding. Now we're going to read a little bit of these notes, right? Watch this. Now it says, hold up, go back up. Now when you start going to do what I'm showing you, you're gonna start having so much knowledge because these notes that they got under the bottom of the civil rules are fire. And like I had started reading them one day, and I'm like, man, let me read these notes. I started reading the notes. I was like, wow, these notes is fire. So it says state certain limitations on applications for the rule, enumerated special proceedings, the expression District Court of the United States appearing in the statute, authorizing the Supreme Court of the United States to promulgate rules of civil procedures does not include district court held in the territories and in secular possessions, right? It says these rules are drawn under the authority of the Act of June 19th. And give you a little code. Then it says that Steve Clark and Moore, new federal civil procedure background. All right, let me go to Rule 2 real quick. So Rule 2, in Rule 2, it says that there is only one form of action. Okay, and that form of action is known as a civil action. Okay, so when you go to court, this is the civil rules of federal civil rules of procedure. Now this is Rule 2 is very, very important. You know why? The reason why Rule 2 is so important is because when we go to court, they tell us that it's a criminal action. They say that when you speeding in the car, that's criminal. When you don't have a seatbelt, that's criminal. A DWI, they say that that's criminal. They say a domestic disturbance is criminal. They label a lot of these things as criminal actions, but when I go read the civil rules of procedure, it says it's only one form of action, and that's a civil action. So now it says it's one form of action, and that's a civil action. Now we're gonna look up. This is what I'm finna, because I'm gonna teach you how you figure this out. Okay. Now, so we know that if it's only one form of action and it's civil, there shouldn't be no criminal actions in court at all. Then if you say criminal action, then that means that you're trying to make it other than something civil. You're trying to manipulate the individual who's being charged into some sort of bullcrap, thinking that he committed a crime, or you're basically what they call, when somebody charges you and takes your name and your information and they charge you with your personal information, that's incrimination. They're incriminating you by charging you with your own information, trying to get you to enter into some deceptive form of agreement, calling it criminal when the law says there's no criminal action at all. The law says it's only one form of action, and that's a civil action. Now we're going to go look up the legal definition of civil action, because I want to know what a civil action really is, because these people going to stop playing with the gods. And I tell you that now. Now look, we're going to look this up. Legal definition of civil action. You look it up too, because I want you to read it for yourself. All right? Because they're gonna have to stop playing with us, man. Check this out. Now, the legal definition of civil action is a legal proceeding initiated to enforce, protect, or redress a private or civil right. So a civil action is an action that's supposed to be to protect you. It's supposed to be for your protection. It involves one party, the plaintiff, bringing a complaint against another party, the defendant, in hopes of obtaining a legal remedy. So he's actually trying to get you to remedy the situation, such as compensation or damages. Unlike criminal cases, civil actions do not involve government prosecuting someone for a crime, right? Instead, they focus on resolving the disputes and compensating for harm. So when they take us into a civil court and they treat it and call it criminal, that's a violation of law because a civil action is not criminal. It's a non-criminal. Listen, and look, they tried to change the meaning of what it means, right? And look up, because a civil action is a non-criminal action. All right, it's non-criminal in nature. All right, they trying to hide it from. Let me see if I can pull it up. Black's Law. Put Black's Law because they trying to hide it from. You hear me? Black's Law. Now, I'm gonna tell you now. It's a see in Black's Law. It says in civil law, a personal action which is instituted to compel payment, or the doing some other thing which is purely civil. So down here it says a civil action. If you see it, if you go on my YouTube, you can see, because I got the YouTube up. It says right here, it says people also acts. It says a civil action is a non-criminal lawsuit that begins with a complaint and usually involves private parties. The plaintiff is the party filing the complaint and the defendant is the party defending against the complaint. Now look, it says a civil action is a non-criminal lawsuit. Now how in the hell is they taking us in on a civil action and calling it criminal? How did you take me to court on a traffic citation and label a civil action as criminal when civil action means non-criminal? That's exactly what it means. When a civil action is something that is not criminal. So if you got somebody in court right now for a gun case, a drug case, those are civil actions. And they're trying to say that they're criminal in nature, but a civil action is non-criminal. It's a complaint against two private parties, meaning the state and the defendant, or the dealership. It's two private parties, yo. It's a civil. It's just like me coming on your lot trying to take your car off your property. That's civil. That is not criminal. If I come on your lawn and I say I work for this tow company and I'm gonna take your car, or if I knock on your door and I say, hey, I need to see your child, hey, I work with DFC or whatever they call themselves, blah, 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 blah. That's all civil. None of that is criminal. None of it. It's all civil. This is a civil-based system. And all civil actions are non-criminal in nature. And when you go to civil rules of procedure, Rule 2 says that all actions are civil. It's only one form of action, and that's a civil action. So everything is non-criminal. Everything. Because they turned it into a non-criminal system when they wanted to get money and do everything. So what they do is they create a subject matter. Speeding. So when you come into court, they throw you off because they're talking about speed, or you were driving and you read down 24th Street and the stop sign said this. They try to get you on that, but behind the scenes, on the books, they converting from this to a claim. And then they submitting a claim in the end. You see what I'm saying? It starts off as a charge, but it ends up as a claim. You know what I'm saying? They convert it. You know what I'm saying? This is what they do. But I want you to understand that a civil action is non-criminal. Whenever they bringing you in, they only bringing you in to help settle the case. Okay, now let's get back to the civil rules of procedure, right? So that's Rule 2. Now, if we go down, it says commencement of an action, civil process, pleadings, motions, and orders, right? So when we click on Rule 3 says right here, it says, Rule 5 defines what constitutes filing with the court. The rule governs the commencement of all actions, including those brought by or against the United States or any officer or agency thereof, regardless of whether service is to be made personally pursuant to Rule 4D or otherwise pursuant to Rule 4E. Now, Rule 4D and E, you need to check those out because it deals with process of service. All right, it says, with this rule, compare formal equity, Rule 12. So it says in Rule 3, it says a civil action is commenced by filing a complaint with the court. So whenever you want to commence a civil action, all you got to do is file a complaint with the court. That's civil rule. You go to Rule 4. Now, Rule 4 talks about the content of the summons. Okay, so if you do something to me, say you T-Mobile or any lender, and I express my rights and I demand that you perform or do something that you originally were supposed to do or promise that you originally made me, and I'm accepting that promise and demanding performance of the promise, right? Now, you default or you don't do what you're supposed to do. I take my proof and file a complaint with the court, right? Because in my notice, I let you know that this notice supersedes our prior agreements that we have. And this will be our contract. You see what I'm saying? Because you're not going to bound me into arbitration. You're not going to bound me into anything. I'm going to create a new contract for us based off of your non-performance, which will give me the rights to enforce this new agreement that I'm enforcing by issuing this notice to you. Because you got to learn how to take control. You got to learn how to enforce law. You see what I'm saying? They keeping you bound under their contract, but you're not creating your own. Okay. So now that I got a contract and he has just accepted my contract by non-performance, acquiescence, or whatever he did, now I'm going to file my complaint because this supersedes all prior agreements that we have, right? So now I take this complaint, file it with the court. Now I get to Rule 4. What you want? Because you see me over here. What is it? What can I help? All right, give me a minute. All right, so in Rule 4, it talks about the summons. It says that a summons must name the court and the party. It must be directed to the defendant, and it must state the names and the address of the plaintiff, attorney, or if unrepresented, representative of the plaintiff. So if you're suing somebody or a company, you got one of the things you got to learn. You got to look up and see whether or not they have a legal representative. If they have an agent that receives legal service or process, then you got to serve that agent. You see what I'm saying? And you want to serve through a third party, a process server, a sheriff, or the Secretary of State, or somebody who serves process legally, right? Now, and not only do you use a process server, a state process server. You've never heard of what I'm talking about, you can Google the nearest state process server to my location, and it should pop up all process servers that are near you. Now, what would you do with such a process server? Brother Isaiah, what would I do with such a process server? Well, a process server is a state officer who has legal authority to serve legal process. Now, one of the most important things about legal process is that if it's not served properly, it can invalidate the whole process. So in order for you to be in compliance with law, because you're not a processor, evidently, I'm not one either. Okay, even though we have the rights to serve, it's better that you get a professional, okay, who does this professionally. Okay, you got certain documents, you got certain claims, you got certain things that need to be known to a specific institution or agent within that institution concerning any rights, titles, or benefits that you're claiming. It's best that you use a process server, okay? It's best that you get a state process server to serve legal process on a bank, on a dealer, on anybody, right? Why? Because the process server, when they serve officially. Now, listen, if you never had one, you need to go try it out. You're gonna be like, oh my God, this is fire right here, because they give you name, they give the time, they tell what documents were served and when they received them, and then they give you an affidavit of service. They come back with an affidavit saying that this, and this was served to this institution, to this person at this time, and then they certify that they issued the documents for you and give you an affidavit. Now that affidavit stands as facts that those documents were served and delivered. Right now, you got a third party for proof of service. Now, that's very powerful and important when you serve in process, legal process. It's very important that you have something such as what I just said. But anyway, so you will file your complaint with the court. And when you file your complaint, you will get a summons form. All right. And the summons form, usually most courts already have a summons form. You just request it, or you go to the law library if you need assistance. Usually the court law library is a great place to go and get resources and documents. I often, when I go to the courts, I often go to the law library on the very top floor. I think that you should use all the resources that are available for you. You want to see a UCC collection, go to the state's law library. Boy, you're going to see a UCC collection like none other. Boy, they got, hey, listen, man, listen, boy, I ain't never say, I said, dang, they got stacks of books. Everything you can think of, forms, documents, it's all there in the law library, but they know the average person ain't finna go. How many of y'all, raise your hand if you just take a day out the week and say, you know what, I'm gonna go down to the court building and go in the law library in the court and just start reading some of the UCC books and reading some of those law. How many of you do that? How many people actually go to the law library in your state court building as a place to do your legal documents? Why not? They got all the resources in there. They got everything. Everything. I ain't playing with you. I ain't playing. If you ain't never been in there, you need to go check it out. Give me a minute. I'll be back.
Everything?
Everything.
Wow.
Who took the top off? You did it, right? All right, so yeah, so I'm back, right? So like I was saying though, make sure y'all get the tap the screen, man. Come on, get them like 700 likes. Y'all better stop playing with me, man. Type of information I'm giving out, man. Hit that screen, man. For real. I'm dropping jewels up here, teaching you how to do stuff, breaking stuff down to you that you didn't even know about. And you can't even like this. I mean, you're supposed to be hitting that screen, man. Everybody always need to give me at least 1,000 likes a piece. Like, stop playing with me, man. Hit that screen. For real. So, like I was saying, right, man. So when you dealing with the courts, right, you gotta know how to actually the process works. So knowing the civil rules of procedure is one of the most important things. So, you know, when you file a complaint, you got to attach a summons to the complaint. And when you go in here and you read this, right, it says the summons must name the court and the parties to be directed to the defendant. So the summons got to be directed to whoever you're trying to serve. It says state the name and the address of the plaintiff's attorney. If they got an attorney or a representative, you got to send it to that person. State the time within which the defendant must appear and defend. So if he got 30 days to respond, or he must appear in court to defend the matter, because this stuff don't take long. When you file your complaint with the court and you attach that summons, it's usually a 30-day process. It ain't, that's why in a lot of their contracts, they want you to do arbitration because they trying to stall you out. They trying to, when you dealing with the court, you go right in, wow, hit that complaint. You got 30 days to respond, or you got to show up on this court date. You know what I'm saying? And if you don't show up, I'm gonna get a default judgment, because a lot of times that's what they do, or they'll try to settle with you before the court date. Right now, it says notify the defendant that a failure to appear and defend will result in a default judgment against the defendant or relief demanded in the complaint. So this is a power move, y'all. This right here, what I'm talking about, this is a power move, because when you send that summons and complaint and you give it notice, he got 30 days, right? You telling them like, look, if you fail to appear or you fail to respond, then this right here becomes your default, and the default judgment shall be entered against you for relief of the amount requested or relief sought. See what I'm saying? That's the whole purpose of us going this route, right? Now, it must be signed by the clerk and it must bear the court seal, right? So it got to have a court seal and it got to be signed by the clerk at the time when it's issued, right? The court may permit a summons to be amended, and it says on or after filing the complaint, the plaintiff may present a summons to the clerk for a signature and a seal. So after you file your complaint, you get your summons to serve, and then you go straight to the clerk and you get that seal and that signature, and then you get a process server and you hit them. You hit them hard. You hear me? You hit them hard. You shoot them. Boom. All right. That's usually the legal. What do you want now? Get one out the drawer. It says the clerk must sign, seal, and issue to the plaintiff for service on the defendant. The summons or the copy of a summons that is addressed to multiple defendants must be issued for each defendant to be served, right? In general, a summons must be served. Oh, look, see this how easy it is. All you gotta do is go in here and read it. It says a summons must be served with a copy of the complaint. The plaintiff is responsible for having the summons and the complaint served within the time allowed by Rule 4. See, keep talking about Rule 4. So Rule 4 is a very, 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 very important rule. Okay, you got to go read it. You know what I'm saying? Rule 4 of the Civil Rules of Procedure. Okay, man, listen, man, I can't make it up, man. Like, we sit back acting like we can't do nothing. You can do something. You most definitely can do something. You most definitely can issue a notice and say that this is a final notice and it supersedes all prior notices and it shall become binding. You got that kind of power. You just got to get the brain to do it, to know your power, because God gave you a free will and he gave you the ability to express thy will. Express thy will, God damn it. Stop allowing somebody to make you do what they want you to do and do what you desire. Express it. Speak it. It shall become what you desire. Okay, if you're a man or a woman with emptiness inside of you, you need to fill yourself up with wisdom, knowledge, and understanding. Okay? And once you fill your vessel up, you can will what you desire. But if you empty on the inside, you ain't got nothing in there. You got to put something in there. You know, you put all the stuff in there to teach you how to dance and wiggle, but that ain't getting you nowhere. You know what I mean? But a bunch of dances. All right, now, it says, any person who is at least 18 years of age and not a party may serve a summons and complaint. So what that means? Yeah, that means you might not have the money for a processor. You know, you probably can't afford one. You know, that's cool. So, hold up. Hey, little cousin. My little cousin, Jody. Hey, Jody, how old is you, Jody? You 18? Oh, you is? Listen, man, I'm going to need you to serve process for me. Yeah. I'm going to draw up a little service, a little document of service. Yeah, you know, you can have it where they can sign for it, but if they don't sign for it, don't worry about it. Just serve them, and and then you can give me an affidavit afterwards, swearing to the validity that you served this, you did that, and what you did, and you give that to me, and that'll be my proof that you served for me as a non-party, because I draw it up and basically saying that you are a non-party, that you're only acting as a witness of service. And we'll draw up a little document, and you know what I'm saying, I have you gonna serve that for me, and then I have you give me an affidavit showing proof that you did serve for me. I mean, listen, y'all gotta be able to think outside the box. Like, man, if you bound in a box, what can I tell you, man? You gotta use this. You know what I'm saying? You gotta use this, man. Listen, man, bright, brilliant. This mind is everything. You gotta give it the right thing, man. You gotta feed yourself the right information. Listen, let me go over this, right? So it says, by a marshal or someone specially appointed, a plaintiff request, the court may order that service be made by the United States Marshal or a deputy marshal, or by a person specially appointed by the court. The court must so order if the plaintiff is authorized to proceed in form of papyrus, man, some stuff is talking about. Now, then it talks about requesting a waiver, right? An individual, corporation, or association that is subject to service under Rule 4. Now, it's talking about Rule 4 again. Like, I can't make it up. Rule 4 is so powerful. Y'all gonna make me tap into Rule 4, but Rule 4, oh man, it's the foundation. 4 represents foundation. So Rule 4 is the foundation to it all. Hey, we're gonna go into it, though. I'm going to it. All right, so a corporation or an association that is subject to service under Rule 4, E, F, or H has the duty to avoid unnecessary expenses of service or summons. The plaintiff may notify such a defendant that an action has been commenced and request that the defendant waive service of summons, and the notice in the request must be in writing and be addressed to an individual defendant or my thing is just jumping around. I don't know why it's doing. Right, so it's talking about like when you suing a company. So like when you suing a company, it's a little bit different because the way that the summons and everything is served, it has to be in compliance to what the rule requires. So Rule 4 deals with how to serve on a corporation or an officer of a corporation, because when you're serving in that capacity, you have to make sure that you're serving things properly in order for you to be in compliance with the actual law. That's why I say, like, depending on what it is and what you're trying to get done, it's best that you use a professional like a process server or somebody. When it all depends on what it is. If it's a mortgage, your home, you really want to be professional. You want to make sure you cross your T's and dot your I's. You don't want to take a chance of making any mistakes when it comes to certain vital property and stuff like that. So make sure you use a process server. And also the Secretary of State access a process server. In most states, your Secretary of State is a process server, and all agents have to be registered with the Secretary. He's the record keeper. So it's easier to have the Secretary serve an agent because they already registered to the Secretary. They got everybody doing business got to be registered, right? I just when you start putting it together, you be like, oh man, it gets a little easier than I thought. Yeah, it is once you know the ropes. Yeah, it ain't hard. But you got to study to learn, who is who and what positions they play and why they play these positions. Yeah. Once you get that, it'll start changing. Make sure y'all get them. Okay. Come on, y'all. Let me get them likes up. Make sure y'all keep tapping that screen. Keep tapping that screen. Please help a brother out. You help me, I'm gonna help you. Make sure you share out the live. This is your first time. Make sure you hit that subscribe or that follow button, okay? Because you ain't gonna want to miss when Brother Isaiah drop, because I'm always giving out gifts. You know what I'm saying? When you come to Building Better Minds, you're gonna feast. We're gonna eat together, and we're gonna digest the food together, and then we're gonna go out and do the thing all over again the next day, okay? We're gonna eat well, and we're gonna get full off this food, okay? Let's keep going. Now it said, for a defendant subject to service under Rule 4H, an officer, a managing or general agent, or any other agent authorized by appointment or by law to receive service of process, because usually when you serve in a corporation, right, you're supposed to serve the agent of the corporation on the corporation's behalf. Same thing they supposed to do for a taxpayer, where a taxpayer is a legal entity too, that's being used by a man or woman as legal identity. It's the same thing. An individual is a legal entity, not a man. Man is what God made. Man is man. Individual is a legal entity. I'm gonna say it again. Man is what God made. A man is a man, and an individual is what the government created, called a legal person. Okay, so don't individually get caught up on who you truly are, because if you get individually caught up, you might end up being a person. Okay, so let's keep it moving, man. Because hey, listen, boy, these people, boy, hey, they've been playing. Ooh, they've been playing on our intelligence. Y'all should be mad. I'll be mad as hell once I find out the truth. And they've been making me a liar. You've been making me a liar. Listen, these people made us liars. You say, well, how did they do that, Brother Isaiah? You've been lying. You've been lying. Ever since you turned 18 years old, you've been lying to the whole world about who you truly are. You have. Yes, you have. What you want? Put your money online. I put my money on. I put money on the wood. Make the business go good, baby girl. Put your money on the wood. I say you've been lying, and you know you've been lying to the whole world about who you truly are. Yes, you have. You've been lying. You've been disclosing who you truly are. You've been hiding behind a person. You've been saying you was a person, but God said you was a man and you was a woman, but you've been telling everybody that you was this person. Yeah. You've been lying, and you even been signing your name for the person's name. See, you've been doing a lot of stuff that you ain't supposed to be doing, but you okay with that. That's okay. You cool with being a person, and God is not a favor of persons. He's not. And I'm gonna tell all you women again. I said again, you're dead wrong. You acting as an informant to the state. You informing the state on a man's property, because the man's property is what you was carrying. That seed that you was carrying in your womb, that you informed on the state of the delivery of the goods that was being delivered to the state. Why didn't you tell the state that those goods belong to that man? You act as an informant, but you didn't tell them who owned the goods. So now the state figuring the man abandoned his child lost the seed, 7 years unclaimed estate. You hear me? And we don't know whether the child is living or we don't know whether the child is dead. And legally, no man or no woman can put her name before the child's father's name first. The father's name comes before the mother's name. That's just the way nature is. That's the way it's set up. When a child is born, he's born with his family name first, and then the mother names the child. So for the child's family name to be behind his mother's name, that's incorrect. That's not how you identify a living person. A living person is not a living person. Living men and women don't have last names. Only persons have last names. Men and women have surnames and given names. So if your record is not a surname and given name, you're not being identified as a human being. You're not being identified as a man. A man identifies by his surname. His first name is his surname, not his. He don't have no. Why would I identify? If I accept the last name, then that means that I deny my family because I allow my family name to be put last, and that ain't how it's supposed to be. So, and because just because they put a last name on your record don't mean you have to accept a last name as who you are. You see what I'm saying? Because that can be dramatically incorrect. And by law, if you have a surname and a given name, nobody can change your surname. Nobody can take away your surname and change the style and make, instead of having it in the front, put it in the back and then make you identify with your name rearranged in the wrong style. You see what I'm saying? So the whole time you running around, you still identifying as a person, but because it's not a surname and a given name, we can't say that this is a natural person. Okay? A legal name can be construed to identify something other than a man, especially if the name doesn't identify the legal person by surname and given name. See, your legal name should be a surname and given name as your legal name, not a first, middle, and the last name as your legal name. No. We ain't gonna worry about the fact that it's in all caps. We don't care about the fact that it's in all caps because we know by default that's how their system works. What we care about when it comes to our legal name is that it's identifying us as men and women. That's what we care about. I don't care about the fact that it's in all caps. I care about whether the names are identifying two separate parts. When I get my passport from the government, it says surname on my passport. It says given name on my passport. So why my birth certificate is not separating that it's two names on it? Why is they putting my name together like it's just one name when you know that a man don't have just one name like that? Every man that I know has two names. He has two names because one name comes from his father and the other name comes from his mother. And by law, those names are separated. They are not one name. That is not correct. So what if I told you that they gave you a name change right at birth? As soon as you was born, they changed the style of your name. They took your surname and made it the last name. And that in itself changed everything. All they had to do was take your surname from the front of your name and put it at the end and make you believe you a person and say, oh, your first name is your first and your middle name, and what is your last name? And get you to accept the last name trickery that they've been doing on us. And we've been accepting this last name because a man has a right to identify by his surname or identify by a last name as a person, because you have two sides. You can either be a man or you can be a person. That's facts. You know what I'm saying? You have dual roles. You choosing to live as a person or as your person instead of the man, the intelligence, the brain, the principle of your person. See, that's the problem. You are the principle of your person, but you're choosing to live as your person. Might be talking over some of y'all ears, but it's okay. Okay, those that's been around long enough, they get what I'm talking about. But I want y'all to go and check out this right here, man, because this right here, it breaks it all the way down how you serve, process, everything, right? Now that you know about that, right? And then it gets into the pleadings, right? And now I'm gonna show you something about the pleadings, right? And then the next time I come on, I'm gonna go into the Supreme Court rules, and I'm gonna show y'all how you go about using those Supreme Court rules, right? Now check this out. Now when you go to let's see. So basically, when they file a complaint, then basically an answer has to be given, right? So let me see. All right, so here it is in it's rule 12, y'all. So say for instance, like when the prosecuting attorney files a complaint against you, right? And you know the court date, right? All right, so rule 12 is defense and objection, right? When and how presented motion for judgment on the pleading and consolidation motion, waiving defenses and pre-trial hearing, right? So when you go to 12, rule 12, it breaks down what the pre-trial hearing and all that's about, right? Let's read this. It says time to serve a responsive pleading unless another time is specified by federal statute. The time for serving a responsive pleading is as follows. Now, this is in general. So whenever you get charged by a cop, anybody on the side of the road, and you got a court date, this is what the law requires. It says that a defendant must serve an answer. It didn't say you must come to court. And nowhere in here does it say you're supposed to appear in court. It says that a defendant must serve an answer within 21 days after being served with a summons and a complaint. So if a cop give you a complaint on the side of the road with a summons, all you have to do is give an answer. All you have to do is give an answer. All you have to do is give an answer in writing within 21 days of the summons or the complaint. Or if it has timely waived service under Rule 4D. So you can waive your rights under Rule 4D. You got to go read Rule 4 within 60 days after the request for a waiver was sent. So see, they request a waiver for you to waive your rights without you even knowing that that's what they're requesting. That's why you need to go read Rule 4. It says, or within 90 days after it was sent to the defendant outside any judicial district of the United States. It says a party must serve an answer to a counterclaim or a cross-claim within 21 days after being served with the pleading that states a counterclaim or cross-claim. So you can either, within 21 days, you can give an answer to the prosecuting attorney's complaint by filing an answer with the court for the complaint filed by the prosecutor. And basically styling your filing as an answer to his complaint and file that into the court. That will be considered in compliance with the law because you don't have to show up. You just have to give an answer to the complaint that's been filed, okay? This is very important because a lot of us don't want to be in no damn courtroom in the first place. It's too gruesome. They try to scare you. They do all these different things to make you feel intimidated. Who wants to go in a place like that? You don't need to be there. Just send your answer in, okay? Simple. Okay, let's keep going. Let's keep going. Now that we understand that you got to send in the answer, now a counterclaim. Now it says on B, it says a party must serve an answer to a counterclaim or a cross-claim within 21 days. So this is how this goes. You file a complaint on me. Okay. I'm going to give an answer to your complaint in the form of a counterclaim. Okay. So I'm going to answer your complaint by denying your complaints, denying what you're claiming. It's denied. This is denied. This is denied. And then I'm going to do a counterclaim. And then I'm going to make a claim against you pertaining to the same subject matter by claiming a beneficial interest, by claiming that I'm a party having a substantial interest in the proceedings. See what I'm saying? And then I claim my interest and demand that my interest be applied to secure me. See, I'm going to show it to you, right? I'm going to show it to you why you got to do this, right? So you got to file, when he filed a complaint against you, you got to file an answer to his complaint within 21 days. Now, when you file your answer, right, you should file your answer as a counterclaim. If you don't know how to make a counterclaim, go talk to ChatGPT. Tell it you need a counterclaim, an example of how a counterclaim would look in a court proceeding. If I wanted to file a counterclaim against a traffic ticket for speeding, it'll draw it up for you and give you an example of what it would look like so you can get an idea of what a counterclaim looks like, right? Now, let's go back. So now we know that, because I ain't gonna read everything, because if I read everything and went all the way down, man, it got so much, it's so much fire in here, right? Watch this. Let me read this little piece. I'm gonna show you how you think I'm lying to you. I ain't lying to you. I'm gonna show you that why you gotta read this stuff, right? Like, look. Now it says a party, I'm at C, a party must serve a reply to an answer within 21 days after being served with an order to reply, unless the order specifies a different time. It says the United States and its agencies, officers, or employees sued in an official capacity, the United States, a United States agency, a United States officer, or employee sued only in an official capacity must serve an answer to a complaint or a counterclaim or cross-claim within 60 days after a service on the United States attorney, right? United States officer or employee sued in an official capacity, a United States officer or an employee sued in an individual capacity for an act or an omission occurring in connection with duties performed on the United States behalf must serve an answer to the complaint, counterclaim, or cross-claim within 60 days after the service on the officer or an employee or service on the United States attorney, whichever is later. Effects on motions. Unless the court sets a different time, serving a motion under this rule alter these periods as follows, right? So you can go in here and read, but it's letting you know that you can sue them. You can sue them in their official capacity. You can sue them in their individual capacity. It's letting you know that they can be sued, that they're not immune from being sued if they violating law. Nobody's protected from the law when they violating the law. Now let's go. Hold on. Hold on. Let me go and get up out of here. So that's so y'all. That's rule 12. That's rule 12. Now, this is the problem that most of us have when we go to court. Let's go to let's go to rule 19. Okay. Rule, no, matter of fact, let's go to rule 18. Rule 18. Rule 18. Matter of fact, 17. 17. Let's go to 17. And we're gonna work our way down. We're gonna work our way down. Okay, so 17 deals with plaintiffs and defendants' capacity in public offices. Let's go that word capacity again. Let's get into it. All right, so designation in general, an action must be persecuted in the name of the real party of interest. Wait a minute. Let's read it again. Designation in general, an action must be persecuted in the real name of the party in interest. The following may sue in their own names without joining the person for whose benefit the action is brought. So you can sue in your own name without joining into the action against the person who the action is brought. So that means that you can bring a suit in your true name against the defendant, an executor, and guardian, an administrator. A guardian may sue in his own name. A bailee may sue in his own name against the defendant. A trustee of an express trust may sue in his own name against the trust. A party with whom or in whose name a contract has been made for another's benefit, and a party authorized by statute. It says action in name of the United States for another use or benefit when a federal statute so provides. An action for another use or benefit must be brought in the name of the United States. The real the joinder of the real party in interest. The court may not dismiss an action for failure to prosecute in the name of the real party in interest until after an objection. A reasonable time has been allowed for the real party in interest to ratify, join, or be substituted in an action, right? After ratification, joinder, or substitution, the action proceeds as if it had been originally commenced by the real party in interest, right? Now, look, so what they saying is that anytime a court case happens, the real man must appear in his real name, or the real woman must appear and make joinder in her real name, not in her legal name, but in her real name, right? Now, check it out. If you don't, then they make you a part to the case because you are a party in interest. So the reason why you're involved in the case is because when you don't do what you're supposed to do, they make you a part. They force you to become a part. Okay. Now, capacity to sue or to be sued. Capacity to sue. Hold up. Give me a second. All right. So now we're talking about capacity. Capacity to sue or to be sued. And capacity to sue or to be sued is determined as follows. For an individual who is not acting in a representative capacity by the law of the individual's domicile. So what it's saying is, hold up, let me just read, man, because this right here is so important that what I'm showing you right now, if you understand what I'm showing you, it'll change things, right? Now, capacity to sue or to be sued. Capacity to sue or to be sued is determined by the following. For an individual who is not acting in a representative capacity by the law of the individual's domicile. For a corporation by the law under which it was organized. And for all other parties by the law of the state where the court is located, except that a partnership or other unincorporated association with no such capacity under the state law may sue or be sued in its common name to enforce a substantive right existing under the United States Constitution or laws, right? Now it says a minor or incompetent person with a representative. The following representatives may sue or defend on behalf of a minor or an incompetent person: a general guardian, a committee, a conservator, or a like fiduciary. Without a representative, a minor or incompetent person who does not have the duly appointed representative may sue or be may sue by a next of friend or a guardian ad litem. The court must appoint a guardian or issue another appointed order. So basically what it's saying is, in so many words, the court expects that whenever they're charging an individual, that the real party of interest, right, connected to that individual be there, right? Now, hold on, that's this rule 19. I'm gonna go to rule 18, joinder of claims, right? It says joinder of claims. A party may join two claims, even though one of them is contingent on the disposition of another, right? But the court may grant relief only in accordance with the parties' related substantive rights. In particular, a plaintiff may state a claim for money and a claim to be set aside, a conveyance that is fraudulent as to the plaintiff without first obtaining a judgment for money. So basically, it's saying that when you bring a claim, you should be bringing a claim for money for relief. And then like when you go down into like the notes, it go deeper. Let me read this right here. Note to subdivision B. This rule is inserted to make it clear that in a single action, a party should be accorded all the relief to which he is entitled, regardless of whether it is legal or equitable or both. It says this necessarily includes a deficiency judgment. Let me put my phone back on the charge this time. So it says that this includes a deficiency judgment, right? This includes a deficiency judgment. Where was I at? In foreclosure action formally provided for in former equity rule 10, decree for deficiency in foreclosure. In respect to fraudulent conveyance, the rule changes the former rule requiring a prior judgment against the owner, and then to conform to the provisions of the Uniform Fraudulent Conveyance Act. So you want to go read the Uniform Fraudulent Conveyance Act because it's basically explaining to you that these people are committing fraud and bringing claims against the owner and making the owner pay for property that he already owned. Now look, now we're gonna go to Rule 19. And then I'm gonna get up off here, right? Now in Rule 19, it says required parties, right? It says a person who is subject to service of process and whose joinder would not deprive the court of the subject matter jurisdiction must be joined as a party. So when you read everything that we've read so far, all the way up until this point, it's saying that a person can sue in their real name. It didn't say your legal name. It said your real name, a real party in interest. You're not a real party in interest if you come in your legal name. Okay, you got to come in your real name as a true party of interest. Right now, let's read this Rule 19 because we want to know how do we make a joinder. I'm gonna show you two things and then I'm out for it. Right, a person who is subject to service of process and whose joinder would not deprive the court of subject matter jurisdiction must be joined as a party if that person's absence, if in that person's absence, the court cannot accord complete relief amongst the parties. So he needs to be joined because if he's not there, the court can't get relief. So they got to join you in some kind of way because they need some kind of relief, right? Then it says that that person's claim, that person claims an interest relating to the subject matter of the action, and he is so situated that disposing of the action in that person's absence may, as a practical matter, impede the person's ability to protect the interest or leave an existing party subject to substantial risk of incurring double, multiple, or otherwise inconsistent obligations because of the interest. So it's saying that the court can't move without you being present because you have an interest in the case. So basically it's telling you that you need to claim an interest. So if you're in a court proceeding, you're supposed to be making a claim of interest as a party of interest, as a party to be added into the case. If you're not making a claim of interest, then how do we know you're a party having an interest? You just the defendant because you're not claiming that interest, right? Now let's keep going. Now, how do we know that what I'm saying is correct? Joined by the court, joined by court order. Now, the reason why you are defended or why you are the debtor in the court case, this is right here. We're going to read it right here, right now. It says if a person has not been joined as required, because it's a requirement that all parties of interest join the court case. If a person has not been joined as required, the court must order that the person be made a party. The person who refuses to join as a plaintiff, so it's telling you you're supposed to join as a plaintiff. It says if you refuse to join into the case as a plaintiff, may be made either a defendant or in proper cases an involuntary plaintiff. So the reason why you become the defendant and the reason why when you go to court they treat you like the debtor is because when you had a chance to enter into the case, you never came in. You never showed up. And because you didn't show up and they needed relief amongst the existing parties already there, and you wasn't going to show up to help give relief, they made you one of the parties that's already existing. And that's the reason why you get treated like the debtor. You know what I'm saying? Because you didn't exist. I mean, you didn't join in. Now let's keep going. It says if a joined party objects to the venue and the joiner would make the venue improper, the court must dismiss that party. So it's telling you if you object to the venue and the venue would have made it improper for you to be in that court in the first place, they got to dismiss you from a party as being a party. It says when joiner is not feasible, if a person who is required to be joined is joined, if feasibly cannot be joined, the court must determine whether in equity and good conscience the action should proceed amongst the existing parties or should be dismissed. It says the factors for the court to consider include the extent to which the judgment renders in the person's absence must prejudice that person or the existing parties. So by you not being present, then that basically that injures the legal person. That injures your account because your account can't receive relief from the claims being made because you can't show up. You're incompetent and you don't know how to verify yourself. You see what I'm saying? And that right there, you know, that right there hinders and hurts you, man, in the long run. Now, let me get down because I'm trying to make something clear to you. Watch this. I ain't done with you yet. Let's keep reading. It says the extent of which the judgment rendered in the person's absence might prejudice the person or the existing parties, because there's already parties that's already existing in the case, right? The extent to which the prejudice could be lessened or avoided by protective provisions in the judgment, shaping the relief or other measures, whether a judgment rendered in a person's absence would be adequate, and whether the plaintiff would have an adequate remedy if the action were dismissed for non-joinder. So the whole time we in the courtroom and they supposed to be joining us in or trying to get us to join in to give relief, but they so deceptive and evil that they just automatically make us the defendant and just start charging us automatically. They don't even give us an opportunity to even join in. They didn't got so used to us being incompetent that they just rule against us automatically, right? Now let's keep going. Check this out. It says pleading the reason for non-joinder. When asserting a claim for relief, a party must state. So this is what you got to do. If you want to get relief, okay, I'm reading it to you now. We're reading it right now. Let's read it again. Pleadings, it is C. Pleading the reason for non-joinder. When asserting a claim for relief, a party must state the name, if known. See, this is what the prosecutor does. All right. Whenever a case is filed against you or your account, and you don't make an entry into the case for that account, right? This is what the prosecutor do. He puts in a request for a reason for non-joinder when asserting a claim for relief. So he's saying that he needs a relief for the subject matter, but he's saying that there's no joinder of the party of interest. So he's making a request through the court for relief, right? It says the name, if known, of any person who is required to be joined, if feasible, but if not joined, and the reason for non-joinder, for not joining that person, right? So that's what he does, right? Whenever you don't show up, right, and defend, then what he does is he puts into the court an order that says uh that you didn't join in and your name is unknown. They don't know who the real owner is, who's acting under that name. So what they do is they basically move against you as if you are the named person because they don't know of no other person acting. See, so that right there in itself is how you get jammed up. Not understanding that you're acting in a legal capacity. And when you're acting in a legal capacity, you got to know how to express yourself whenever you're dealing in your capacity as the taxpayer. All right. With that said, y'all, I hope y'all really enjoyed it and like what the message that I brought forth. Y'all go back and study this stuff. Go back and read over the silver rules. Take your time and just read the rules. You can't do nothing but benefit by educating yourself. You want to learn more about what's going on, go in here and read. Once you start reading this stuff and you start seeing, you'll be like, oh wow, it's right there for you. You just got to go pick it up and read it. Everybody has the same rights. Nobody has greater rights than the next one. Ain't nothing that nobody else is doing that you can't do. You just gotta acquire the information and then enforce it. With that said, man, y'all have a blessed, y'all have a wonderful day. If you like what I'm doing, you can always reach us at buildingbetterminds.info if you need any of our services. If you want to talk to me one-on-one, if you got any issues going on with any financial transactions, accounts, or anything, and you're trying to seek relief from amongst a lot of these different things that you may not be knowledgeable of, then come tap in with your brother and I can give you some information that I know that will be life changing and liberating, man, because we're living in an age of information and there's no reason why no man, no woman shouldn't be equipped with all the information and the tools that they need for this day and time. With that said, I leave you as I always do in love, truth, peace, freedom, justice, and equality for us all. Y'all have a blessed, y'all have a wonderful day. Study, study, study. Show thyself approved and salute to all my real ones.